The main three header topics of a family law case or divorce in California consists of division of assets and debts. We refer to that jointly as property, custody of children and setting up a parenting plan, and then support. Within each of those three categories, there are a lot of nuances and twists and turns in terms of figuring out how those things are going to be resolved. The important overriding issue with regard to a family law case in California dealing specifically with property is that California is a community property state. Most of us understand community property means that whatever we acquire during our marriage, between the date of marriage and the date that we separate, is community. It means it belongs to the couple. And upon a separation or divorce, those things have to be divided equally unless the parties agree to something else. In the absence of an agreement, the court is going to split everything down the middle. Now, the reality for that situation is that most people end up having to sell things because, for example, if a family has a residence, usually it's a situation where one cannot afford to buy the equity of the other person. It's usually, several $100,000s in the current housing market to do that. And on one income versus two, the ability to afford to do that is very difficult. So it may involve selling the house, paying off debts, and then dividing what's left over. One of the biggest assets people tend to not think about in terms of asset division is retirement plans. Probably on a plane equal to the value of a family home or the value of retirement benefits. And so when we're dealing with a separation or divorce, it's important to take a look at that and make sure that those benefits are being properly accounted for, and to the extent that they were accrued during marriage, that they're being divided. So a person doesn't leave something very valuable on the table when they're terminating the marriage. Custody and visitation is probably the hardest part of a family law case. It's the most emotional. For most people with small children, it's the most important. The goal of any good practitioner and the court is for mom and dad to develop a parenting plan together. The goal is to try to make sure as much as is possible that mom and dad remain united in terms of how they're going to raise their children in two different households. To avoid conflict, especially in front of the children. One of the worst things that can happen to kids is to go through divorce, and to make it more difficult is to go through divorce where mom and dad just simply cannot get along. It causes an enormous amount of stress on kids. It causes a lot of difficulty for kids. And I think unwittingly, a lot of parents tend to feel that if a child wants to have a bond or relationship with the other parent, it almost feels like they're being betrayed. And parents can't look at it from that perspective. They have to look at it from the perspective of a child who loves both parents and wants both parents and wants to be part of both parents' lives. And parents need to separate themselves as best as they can from what their emotional needs are and look at the situation from the needs of the children. That's the best course of action in terms of coming to an agreement. As a lawyer, part of my job is to make suggestions and talk with clients about things that concern them about their kids, talk about the needs of the children, and that can be very age specific. Teenagers have very different needs than a 4-year-old. A teenager is going to have a lot of other things that are dynamic going on in his or her life. Peers, activities, extracurricular events, dating, driving a car, things that are going to need to be dealt with in a very different way. So part of my job is to understand the needs of the child, understand the needs of the parent, and make sure that my client understands that they need to do everything they possibly can to meet the needs of the child. Unfortunately, sometimes we have situations where we don't really have two good parents, and those are very difficult cases. Sometimes it involves substance abuse, sometimes it involves alcohol abuse. Sometimes it involves physical abuse, those kinds of situations. So there are situations where we have to assist a parent in stepping up to the plate to make sure that the children are being protected from a dangerous situation or environment. Support is a tough situation too, because a lot of times the reason for a divorce in the first place is financial stress, and the breakup of a marriage involves typically two households now being supported on the same amount of money that was already a struggle for one household. So it can be challenging because trying to figure out what, if any, support liability for children may exist. How do we calculate that? How do we deal with that? Spousal support or alimony, all kinds of factors. But understanding that with regard to a support obligation, the law, the court looks at a support obligation as the primary financial monthly obligation that a person has. If there are other bills or debts or things that make support a challenge, the unfortunate reality is the law is not going to consider those things as primary. They're secondary. And so sometimes we have to help clients with very difficult financial decisions, often affecting lifestyle changes, to ensure that if they're a recipient of support, they're getting what they need in order to meet their needs and adjust their lifestyle, their expenses. But if they're a person that's having to pay support, doing the same thing, adjusting their lifestyle and their expenses to make sure that they can meet their obligations. Grounds for divorce in California are really simple. Under California law, California's a no-fault state, which means it doesn't matter why a person wants to end their relationship. The most used ground is called irreconcilable differences, which means that I'm not happy in this relationship. I just want out. And it's really nobody's business why a person feels that way. The court is never going to ask why. It's basically, the question is, are there differences in your relationship that can't be reconciled? And if the answer is yes, that's enough. That gets us where we need to be. There is also a second ground for divorce called incurable insanity. And 29, 30 years of law practice, I think I've had one case where a client asked me to allege that, and it is a basis for divorce. There's no legal advantage to claiming incurable insanity over irreconcilable differences. It exists. And I tried to talk my client out of it. She said no, he was crazy, and she wanted the world to know it. So in any event, that's a basis. The time to get a divorce varies significantly. My record time in getting a divorce completed in California, I think, was 3 days. And I need to distinguish the difference between getting the paperwork completed and a judgment signed by a judicial officer or judge versus the time when the marital status ends. So it's often confusing to people. Under California law, after a person begins the process of a divorce and the other party has received notice of that, they've received paperwork, then the marital status cannot change from married to divorce until at least 6 months has passed. The theory behind that is we want to give people time to reflect on a very serious decision, and if there's any opportunity that the passage of time may bring toward healing the relationship, then the legislature wants to make sure that that opportunity is given. Can't waive that, can't change it, can't do anything about it. 6 months is 6 months. Now, the confusing part is this. We can actually complete the processing of a divorce and implement the judgment, the final orders, as it relates to the division of assets and debts, as it relates to whatever support obligation exists, as it relates to a custody order. in a time that is much sooner than that 6-month period of time. So a person can actually complete their case, have it stamped, signed, sealed, delivered in as little as 3 days is my record. More typically, if it's an uncontested case, everybody's in agreement on everything in a period of probably about 3 to 4 months. But you are still legally married to that spouse until that 6-month period of time passes. And I know that's confusing, and a lot of people struggle with that, but it can be done. Your case can be completed. It can be legally effective as to everything except you're still married to this person. Cases can go on for a much longer period of time. I have had cases where people were highly contentious, especially with custody and disputes and allegations over abuse and things like that have literally gone on for years and years. 5, 6 years, I've seen it. And so people can go back and forth. Now, most counties in California will track the progress and status of a case and require that the parties or attorneys for the parties appear in front of the judge periodically, usually about every 6 months, and report to the court the progress of the case to ensure that things are not sitting idle and not getting handled and done. Most judges will be very active in terms of making sure that a case gets to completion within a somewhat reasonable period of time, probably 18 months to 24 months, even in a contentious case. But if there's a lot going on and it can't be done in that period of time, it can go longer. Some counties are completely hands-off. You can file a case in the court and it can sit there forever and nobody ever touch it. So it really depends upon the county that you're in. It depends upon the judge that is assigned to the case. It depends upon the goals and objectives of the court. It depends upon the goals and objectives of the parties. It depends upon the reasonableness of the parties. It depends on how worn out people are. Sometimes, people are very anxious and aggressive even at the beginning of a case, but throughout the course of time, because it is highly emotional and challenging, may get to a point where you just want it to be over no matter what. And so part of my role as a lawyer is to navigate all of that, make sure that each client understands the potential length of time that we're looking at, the level of commitment that a client has, understanding the goals and objectives of the client, and balancing all those things in terms of a timeline that is workable, but also making sure that a client is not unrealistic in their expectation of what amount of time or commitment is required in order to get the case from beginning to end.